All right, it's 2 minutes after 8. This is Morning Express, and we'd like to get into the debate on what the country holds in terms of that advice given by the CJ to the president to dissolve parliament. Now, the life of Kenya's 12th parliament hangs in the balance after Chief Justice David Maraga wrote to President Uhuru Kenyatta advising him to dissolve parliament in accordance with Article 261 of the Constitution for failure to enact the two-third gender rule. In his 10-page memorandum to the head of state, Maraga says he has received a total of 6 petitions on the matter and is time to endure pain in order to remind the country that choices, particularly on constitutional obligation, do have consequences. We now look at KTN senior political reporter Duncan Khaimba tells us more on what has been unfolding.
This is the 10-page letter from Chief Justice David Maraga to the President, demanding that he moves with speed to dissolve Parliament for failing to obey the Constitution. CJ Maraga is armed with 6 petitions tabled before him in the matter for dissolution of Parliament as filed by Margaret Toili, Frederick Gishanga Mbugwa, Stephen Owoko and John Wangai, Aoko Bernard, former Member of Parliament David Sudi, and lastly, the Law Society of Kenya, LSK. The petitions based on the ground that, despite 4 court orders compelling Parliament to enact legislation required to implement the two-thirds gender rule in accordance with Article 27(3), read together with 81B and Article 100 of the Constitution, Parliament has blatantly failed, refused, and/or neglected to do so. It is on this premise that Chief Justice Maraga tells the President that, and I quote, "There is no doubt that dissolution of Parliament will cause inconvenience and even economic hardship. But in the circumstances, as a country, let us endure pain, if we must, only if to remind ourselves as a country that choices, and particularly choices on constitutional obligations, have consequences." He adds, "Let us endure pain, if only to remind the electorate to hold their parliamentary representatives accountable. Let us endure pain, if only to remind ourselves that as a country, being a democracy that has chosen to be governed by the rule of law, we must say no to impunity and hold everyone accountable for their actions or omissions." Ending by saying, "It is my constitutional duty to advise you, the President of the Republic of Kenya, which I hereby do, to dissolve Parliament in accordance with Article 261(7) of the Constitution." End of quote. In an exclusive interview with KTN News 2 weeks ago, LSK President Nelson Havi stated that President's action on the matter is inconsequential, given that once the Chief Justice writes to him, then Parliament automatically ceases to be lawfully constituted, and whatever is transacted thereafter becomes null and void.
It must be understood by the people of Kenya, if the Chief Justice will advise the President to dissolve Parliament, then effective that day, Parliament ceases being lawfully constituted. It doesn't really matter what the President of the Republic of Kenya will do. All laws that will be made by Parliament subsequent to the decision of the Chief Justice will be null and void. All actions, all oversight, all investigations will be of no consequence. And by doing so, the Chief Justice will have vindicated the rule of law and ensured that the Constitution means something to the people of Kenya.
National Assembly Speaker Justin Muturi had touched on the petition a few days back.
We should not be indeed worried about the fact that the 12th Parliament may come to an end and that there could be some impending retirement.
As to whether the President will execute this colossal constitutional duty once it lands on his table has been a question on many people's mind.
It is on this backdrop that the failures of the administration of President Uhuru Kenyatta can be highlighted. They do not follow the law. They consider the law as a great inconvenience.
The country will be waiting with bated breath to see what step the president will take. Duncan Haimba, KTN News.
All right, and that's the debate we'd like to engage in and just see what's the way forward. But allow me to read some of your comments that have come through before I introduce the guests that we're going to be having here this morning to have that debate. And the question we had asked is whether you feel Parliament should be dissolved as advised by the Chief Justice David Maraga. We have Cryptic who says Uhuru will do whatever he pleases. What Maraga? I guess not much confident as to whether the president is actually going to, if at all he has anything to do. Let him do it. We know that it's just another way of fabricating a thing that went bad. We have Mwalimu who says, we are tired with corruption. Let him dissolve Parliament. I'll read one more. Nelson Kombo who said on the 17th of August 2017, the President of the Republic of Kenya took an oath to protect the Constitution. Therefore, he has to do so and adhere to the CJ's advice. And the discourse continues. So, would like to hear your comments. Again, that question is, should Parliament be dissolved as advised by the Chief Justice David Maraga? The hashtag is KTN Morning Express. If you'd like to tweet, it's at KTN Kenya. And you can also tweet me directly, and that's at Michael G. Gitonga. Let me introduce the guests that we have here this morning. And we are joined by Anne Ireri, who is the CEO for FIDA, joining us this morning from our town studio. We'll also be joined as we go along by Degwa Jiro, who is a constitutional lawyer. But so far, we have Anne Ireri. Good morning, and thank you for joining us. Let's get straight into it, and let me hear your comments, Anne, as to whether you feel this might be too little too late from the CJ.
Thank you very much, Michael. It's a pleasure to be here. It is a great day for women in Kenya. We herald the decision by the Honorable Chief Justice, coming 10 years later, a decade. And for us, it's something that we have worked tirelessly towards. If Kenyans can recall, this provision was one of the first matters that was really challenged at the Supreme Court way back in 2012. And we could see a bit of cold feet to really implement this provision that really seeks to actualize gender representation in this country. And so it is really, really a great moment for women in Kenya. And we are now, all eyes are really on His Excellency, the President. We expect him to do the right thing. It is a question about adherence to the rule of law and really, really addressing the question of impunity in this country.
All right. And do you think we need to change the narrative and have a paradigm shift? You've said it twice. It is a great day for women in Kenya. Is it a great day for women in Kenya, or is it a great time for gender parity in Kenya?
For us, Michael, for FIDA, our situation is that it is both. It is important for Kenyans to understand how we got to where we are at. Way back in 2010, when we were promulgating the Constitution, this was a culmination of really, really a lot of clamor by the women's movement to have Articles 27, Article 81, and Article 100, alongside other groups such as the youth and persons with disability, that for the first time in the Constitution, we were really having a situation where we are guaranteed of an equal space at the table that was not there in the past. And so for us, what we are urging Kenyans to look at is that we are not just pushing for representation for the sake of it. It's not about women wanting free seats. It's appreciating that, first and foremost, women constitute a large demographic of this country. We are 52%. Secondly, we are faced with a myriad of issues such as socioeconomic rights, violence against women, economic challenges, which require women at the table, same with men, to be able to articulate and to really push these issues forward and to have progressive legislation. However, historically, we have had challenges in terms of getting women to elective positions in Kenya.
Right.
We are looking at a very gruesome culture of violence in this country during politicking. Women have challenges accessing financing in terms of politics, as well as stereotypical attitudes that we have inherited over time, where we tend to feel women cannot be good leaders for various reasons. And that's why Article 100 was very important to level the playing field, to ensure that we have women at the table. Over and above the special seats, which are 47 in number, we have seen women who have been able to fight it out in traditional constituencies, for instance, both at National Assembly and at Senate. And once they're in the House, we have seen the impact of having women leadership in this country that's translated in progressive laws that affect not only women, but also men and the community. And so we are urging Kenyans, over and above, as looking at it as a question of rule of law, it's about really acknowledging women need to be given equal space at the table, not because we need to fight it out or we are trying to compete with men, but because it's a fundamental, proper, right thing for any country that's keen on development to do.
Absolutely. And this, we know, is to incentivize the political class, this move by the CJ. And of course, like you mentioned, it is really just the rule of law. But there is a reason as to why we have gotten here. And other than just have it inscribed as a law and followed and adhered to, there's a reason why there has been hesitation and literally just, disregard to the law. What are your thoughts on how we have ended up here? And once it has been actioned, we are hoping and waiting to see what the president is going to do. But there needs to be a paradigm shift even in how we operate.
Absolutely, Michael. I think what this really exemplifies is the perception and how we approach women issues in this country. The sad thing is that when we look at the schedule in the Constitution, Schedule 5 actually gives a grace period for the parliamentarians to be able to implement legislation to actualize Article 100, which is the longest, 5 years. So when we look at from 2010 to 2015, and we are now 5 years late, it's really just a question of prioritizing the women question in this country. And that's what we have been saying all over. Why is it that it is only when we come to the gender question that we have exceptions? We have, lawyers who, like myself, should really know it's about a question of the rule of law, indicating that now it is really, the word is shall, it's discretionary. That means that it's not a must, it's not mandatory. And so that's what we are trying to make Kenyans understand. The land question in this country was really articulated. We had provisions on it, legislation was enacted. In terms of division of revenue, we have seen the priority it's been given. In terms of health matters, in terms of infrastructure. So why do we want as a country to give women a road deal? And that's what we are really questioning, because we get to be relegated to second-class citizens that now when it comes to women issues, it's no longer a priority. However, this is where the dangerous point is. It's a question of the rule of law, and we need Kenyans to understand. Today, it's a question of gender parity that's been relegated to the back door. Tomorrow, it will be a fundamental question such as the right to health. It will be about access to certain rights. And so we need to be fair to the women of this country who, in 2010, overwhelmingly promulgated this constitution on the promise that once and for all, the question of representation was going to be addressed. So I still reiterate, it's about how we prioritize women issues in this country, that when it comes to the women aspirations, all of a sudden we feel it's not mandatory, which is not right. I think we need to be bold and let Kenyans know we are giving women a road deal in this country. The Chief Justice has been very clear on this. All eyes are now on His Excellency, the President, and we really expect him to do the right thing. All
right, and this, of course, should not even be a debate right now, given that it's enshrined in the law. And like you've rightly put it, we are running 5 years late, which, of course, has a reason now. Truth be told, what is your expectation, given that we are we have an executive that has been accused of disregarding the law. And of course, this has come time and again. This is not the first time that this debate is being had. We've even had lawyers who've tried to, dissolve parliament, but this has not happened. But now, from the Chief Justice himself, what do you see playing out?
I think in terms of the procedures going forth, I think the law is quite clear. His Excellency, the President, has a period which should be 21 days to actualize the next steps towards either dissolving Parliament or giving Parliament an ultimatum. I think those are the options they have. And I think for us, what is important, Michael, is again putting it in context, that we are hoping the 12th Parliament will appreciate what it means to have women at the table in terms of decisions. Yes, we've seen a number of attempts. I think we've had 4, 5, close to 6 times to really push legislation. And we've seen women leaders, especially at the National Assembly, rallying their colleagues, being able to push this. But the question is, the buck might actually now stop with His Excellency the President and the political parties. We now need answers. Why is it that these bills fail to take through because of lack of quorum? Why do women leaders as well as allies who are men have to burn the midnight oil trying to lobby for this legislation? This is how we have gotten to where we are at. Yes, attempts have been there, but one, we have not been serious about pushing this legislation, and now the chickens have come home to roost. I think that's the reality we are facing. And so we are really hoping that one, His Excellency the President does the right thing within the 21 days that he has. But secondly, that now the National Assembly has this last chance to redeem themselves and to at least prove that they have the will to push this legislation, and it's actually ready. It is in Parliament to now really take it through the House, and finally we can have legislation actualizing Article 100 before we go to the next election in 2022.
All right, and we are now joined by Degwa Jiro, who is a constitutional lawyer. Thank you for joining us, sir. And we are, of course, discussing the advisory given by the CJ to the President on dissolving of Parliament. What are we staring at, and what's the way forward? Does the President really have a choice in this?
Thank you, Maura and Anne, for the interview and for the invitation. Well, Maura, we are in a situation whereby we must dictates of the Constitution. If we are actually serious in ensuring that there is an established Republic of Kenya that is premised on the dictates of the constitutional democracy. What that means, Maura, is that we all know where we came from and the history of this legislation, and slight difference with a slight variation with Anne's position, that this legislation is not about the women, it's not about the girl child, it's about the gender. Gender means me and you and Anne. Tomorrow it is the women who feel, today it is the women who feel a bit discriminated or a bit unappreciated. But tomorrow it might be the boy child. So this law will apply mutatis mutandis, both to the men and to the women. And the question is then, does the President have a choice? The question and the answer is that the President has no choice out of this. Again, a small variation. The President cannot even larry the Parliament as at now. Why? Because with the Maraga's position, remember Maraga is conveying a judicial decision that was done by Justice Mativo in 2015. His advice is premised on that petition. So it is a judicial process that has taken place, and it has involved the people. The people have been involved with the process of exercising their sovereignty, because that is why the Constitution contemplates people going to court, petitioning the court issuing directives being transmitted to the Senate and to the National Assembly, and also being transmitted to the Chief Justice to supervise the process of the implementation of that law. And in the absence of the implementation, an advice to dissolve Parliament. So it is a constitutional process that has followed the due process of the law. And then what that means is that the President does not even have an option of even advising Parliament as at now to enact that legislation. Why? Because the moment that advice was done, the legitimacy of the parliament, and parliament means the National Assembly and the Senate. Because if you look at Article 96 of the Constitution provides that there is established the Parliament of the Republic of Kenya, which shall consist of the Senate and the National Assembly. So the two houses are actually affected, and their legitimacy has actually been thrown into limbo. So they basically do not have the legs on which they can actually subpoena themselves into Parliament and pursue or enact this legislation. So their existence is actually in a serious legal quagmire. So the only remaining option is for the president to heed to the constitutional advice as granted by the Chief Justice.
Ndegwa, and maybe just a slight correction there. The name is Michael Gitonga, not Mwaura. But
sorry, Michael Gitonga. Michael Gitonga. I'm sorry, Michael.
Okay, no problem. But having said that, I want to fully understand when you say the president has no choice, and yet we're waiting for him within 21 days. What are we waiting for? Are we saying that as we speak, based on the advisory by the Chief Justice, we actually do not have a National Assembly and Senate?
Pursuant to the advice by the Chief Justice, the Parliament of the Republic of Kenya has become lame, legally and constitutionally lame. It shall be crystallized and catalyzed by the action of the president to dissolve. So as at now, we have a parliament, but the question is whether that parliament has the legislative capacity to pursue any other legislation if they have actually failed to pursue this one. On what basis will they premise their subsequent legislations and their subsequent actions if they've already failed to legislate this? It's more important, Michael, to understand that there is no legislation that's superior to the other. All legislations enjoy the same presumption of constitutionality. Whether we are legislating on gender parity, whether we are legislating on any other action, they actually stand on the same constitutional footing. So the question is, the president has no option other than to heed to this process. And where is he going to, where is the time period? The time period is coming from the Statute of General Interpretation. Cap 2 of the laws of Kenya provides for the time period within which an action is to be done if that action has not been prescribed by the law. If an action is supposed to be done by a state officer or a public officer, and for this case, Parliament or the President, and the law has not given the prescribed period, we revert back to the Statute of General Interpretation for us to get the period within which that action must be done.
All right, let me come to Anne. And Anne, assuming that this happens, and of course, we're waiting to see whether that, within that 21 days, whether that is going to happen. What is it that you foresee or you would like to see happen moving forward? Even if the law is put in place, there needs to be a paradigm shift in how we view gender, in how we operate as gender, by making sure we all have an equal playing field.
Thank you very much, Michael. What now really we are going to be spotlighting are the political parties, bearing in mind that they're really the main vehicle that both men and women are used to get themselves into political leadership. So we'll be very keen, especially within the large political parties, to really have dialogue with them, to have measures that really push them to enforce the question of gender parity, where we, one, have very, very clear guidelines on eliminating political violence in this country. We will want political parties to really vouch and indicate that they'll want women at the forefront. We'll be clear about really the women who've prepared themselves, accessing political financing so that they don't face it as a barrier. But most important, I think we will really want to be to disseminate the question of dispute resolution within parties. This is important because this is where a lot of women are shortchanged, especially in the nomination stage, when it comes to the electoral day itself, as well as beyond that, where we have the party lists that really help women still make it to parliament, be it Senate or the National Assembly. So I think we'll be very, very clear on that to work with the political parties. We will also be keen to strengthen the work of the IEBC as well as the Registrar of Political Parties to enable women, because these are some of the channels where we can be keen and deliberate to have women facilitated. And again, we reiterate, women are not asking for free seats. Women are ready, they have been working overtime, they've been mobilizing themselves, they've been planning their finances, but we need that political will that's backed by the executive, especially when it comes to institutions such as the National Police Service, so that first and foremost, we have very clear implications for perpetrators of political violence, people who we know intimidate women, but secondly, we have clear sanctions that can be relied upon. Again, a test of the rule of law. But it's important to state, and again, what my learned colleague has stated, Mr. Ndegwa, that we have found ourselves in this quagmire as a lesson for the country. It is really about the question of the rule of law. We have numerous legislation in this country that really are disregarded, and unfortunately, again, most of them have to do with women and special groups. So we need to have that period as a country to reflect, to introspect. What does it mean to really adhere to the rule of law? Do we have legislation and a constitution for the sake of it? Do we have the political will? Do we have the national will to hold office bearers, such as our local members of parliament, to ensure that they actually hold the executive in check in terms of implementing the law fully without really choosing or relegating some form of legislation to second class or third class because it is perceived not to be important.
Not to be important. All right. And allow me to read some of the comments that are coming through before I come back to you, Ndegwa. And of course, the question that I'd like to pose to you is what happens if we just remain with status quo, assuming the president, goes business as usual and 21 days later, we still have done nothing. But let me read some of the comments. Julia says, let our women compete for the available elective positions on a fair ground. I strongly oppose the issue of sneaking slay queens into the houses, both national and county. And one might say that maybe he's missed the point there because we're talking about the rule of law here. Patrick says, big thinking is needed first before dissolving Parliament. Kenya's spirit of constitutionalism is being tested herein. The president should defend the law that he swore to uphold and protect. James says, yes, he should dissolve it. It has failed in its mandate. Mr. Njiro, tell us what happens should the president, turn a deaf ear to what the CJ has
What
advised?
happens is that, again...
Yeah, go ahead.
What happens is that we shall have a constitutional crisis because we'll have a situation whereby the legitimacy of Parliament has been questioned. Any subsequent action that the Parliament then undertakes shall also suffer the same consequences of disrepute. And then we also have a situation whereby we cannot punish the president by impeaching him because the houses that are supposed to impeach him, that the National Assembly and the Senate, will have suffered the legal illegitimacy. So we'll be in a situation whereby the president has abrogated the constitution. We'll be in a situation whereby the president has decided not to follow the dictates of the constitution that he swore to defend. Then we shall also be having a situation whereby any subsequent action that the parliament shall be undertaking shall be subjected into legal dispute. Secondly, we will just be throwing this country into a situation of legal limbo. But the good question that we want to ask ourselves is whether this advice has presented the country with a rare opportunity of staggering our elections. Remember, Mike, the Kenyan elections is a very compounded and crowded process where we are electing people 6 offices in a day. Most of the Kenyans are not even able to distinguish which office are we establishing. So we now have an opportunity of, first of all, establishing Parliament where we're electing the women rep, we're electing the senator, and we're electing the MP for 2 years before we elect the office of the presidency and the county elections. We'll have an opportunity of now staggering our elections, in a sense that the president will be serving his term, will be finishing his term during the existence or the subsistence of parliament. And when the parliament's time expires, there shall exist the presidency and shall be existing the county offices. So we have a real opportunity for us to now stagger what we have actually been looking for. We stagger our elections so that our elections are not conducted on the same day. I think it's one of the opportunities that this advice has granted unto us, and it's upon us now to seize the opportunities so that during the time of decision making at the election time, people have a sober process of electing sober individuals. The reason why we have this problem, and the reason why Anne is speaking about the issues of political parties, the nomination list, the nomination of the political parties, is because the election is always compounded. On the same day, we are nominating an MCA, we are nominating the women rep, we are nominating the senator, we are nominating the MP, we are nominating the MP. So, and you're also nominating the governor. So the elections become very compounded, and people are not able to make sober and sound decisions. This opportunity is a rare opportunity for this republic. It shall be a rebirth of the Third Republic, where the functions are completely distinguished, and the establishment of those offices are also distinguished.
All right, ladies and gentlemen, let me get your closing remarks as we wind up. I'll start with you, Anne, your closing remarks on this and possibly your expectation.
Thank you very much, Michael. Once again, we reiterate, this is really a special moment for women in this country as well as men. It has been long coming. We really laud the Honorable Chief Justice for making that very bold decision. And I think for us now, our eyes are on His Excellency the President. I think the women of Kenya will really be looking at him. We expect the right thing. But most importantly, and to be pragmatic, is that this has given us a silver opportunity as a country to really reflect and introspect on our position on the rule of law. Why have we gotten to where we are, and what options progressively can we make to actualize not only the reality for women's dreams, but the myriad of other issues that are really stuck because the rule of law has not been implemented and impunity has carried the day. So really, really, we hope His Excellency the President will do the right thing, and women will be watching what he's going to do next.
All right, and Degwa Jiro, your closing remarks.
Thank you, Mike. Thank you, Anne. The country has an opportunity to do a rebirth of the Third Republic, a Third Republic where the rule of law reigns, a Third Republic where the rule of law speaks to the heart, the Third Republic where Article 10 of the Constitution shall reign supreme insofar as the creed and the fidelity to the law is in issue. We have an opportunity of staggering our elections so that we separate the most usually compounded elections. And thirdly, we have an opportunity to teach the world that yes, in this republic, the rule of law reigns, and that the independence of the institutions that we have established is respected and upheld. So the institution of the presidency must return this honor by honoring the people of the Republic of Kenya who established all the offices, the office of the Chief Justice, the office of the Parliament, and the office of the Executive. It's an honor that the President shall show unto us that yes, I am a President who respects the rule of law. Yes, I am a President who observes the dictates of constitutionalism, and one of his legacy that he will have left to this country, and he has been working hard to leave that legacy. The President has been working hard to leave that legacy, is to leave a legacy where the rule of law and the fidelity of the law is respected and upheld. So, Mr. President, we challenge you, Mr. President, to observe the dictates of the law. We have no sympathy for wrongdoers. The law has no sympathy for wrongdoers. And mark you, Mike, we say that it's better to jail 100 people than jail one innocent people. So the people of Kenya are innocent. They have suffered the inability of parliament to actualize their functions. It is now your time to save them, Mr. President.
Thank you very much. Ndegwa Njiro there, a constitutional lawyer, and Anne Ireri, who's the CEO for FIDA. Thank you for joining us this morning and having this debate on the way forward in regards to that advice by the Chief Justice David Maraga to the President to dissolve Parliament. We are still looking to your comments that are coming through on that question as to whether that should happen. But for now, we're going to take a short break, and do stay with us right here on Morning Express. We still have another 23 minutes of the show, and we have stories lined up for you. So we take that break, but do stay with us.